The Centre for Public Legal Education Alberta, CPLE, is a non-profit organization with the goal of making the law understandable for Albertans. CPLE provides legal information and education to the public. Only lawyers can provide legal advice. Look for our contact information at the end of this video. Enjoy!
When it comes to planning for the future, you may hear the phrase mental capacity used often. Do you have mental capacity? Have you lost mental capacity? Is your mental capacity fading? Do you need a capacity assessment? This video will explain what mental capacity is, why it is important, and how it is assessed. So what is mental capacity? Mental capacity is defined in Alberta laws as the ability to understand information related to making decisions and the ability to understand the consequences of your decisions. For example, if you are making a decision about whether or not to proceed with a serious medical treatment, you must understand what the medical treatment is, the procedure, the risks, the benefits, the time frames, recovery, etc. You must also understand what will happen if you decide to have or not to have the treatment. If you decide to have it, how will your health change? If you decide not to have it, how will your health be impacted? All adults are presumed to have mental capacity. Deciding whether mental capacity has been lost is a significant responsibility and has to be supported by expert opinions. Legally speaking, mental capacity is black or white. You either have mental capacity or you don't have capacity. For example, if you want to make a will or a personal directive or an enduring power of attorney, you must have full mental capacity. In reality though, mental capacity is measured on a spectrum. You can have varying levels of capacity, from full mental capacity to some mental capacity to no mental capacity. Mental capacity is a complex thing. Loss of capacity can be sudden, or it can be subtle and gradual. Your capacity can change over time. This can be the case if you are suffering from a degenerative condition, such as dementia. Whether you have capacity to make a decision depends on the kind of decision being made. You can have capacity to make some decisions, but not others. For example, you may have capacity to make routine, day-to-day decisions, but not to make a decision about a serious medical treatment. Your mental capacity may be affected by a medical condition, stress or anxiety in difficult situations, the effect of medication or forgetting to take medication, exhaustion and the time of day, fluctuating blood sugar levels due to diabetes, or alcohol and recreational drug use. So why do we care about mental capacity? Why is it so important to understand? Well, you need full mental capacity to do some things, such as sign a personal directive, create an enduring power of attorney, or make a will. For more information about personal directives, enduring powers of attorney, and wills, see our video in this series on that topic. You also need full mental capacity to deal with property and banking, enter into a supported decision-making agreement, or enter into a co-decision-making agreement. For more information about supported decision-making authorizations or co-decision-making orders, see our video in this series on decision-making tools. If you do not have full mental capacity and you sign these documents, someone could challenge them and the court might decide the documents are not valid. This could leave you without the legal plans you thought you had made. So who assesses capacity? Well, different people can assess capacity in different situations. Lawyers can assess your mental capacity if you are signing legal documents with them, such as a contract or a will, personal directive, or enduring power of attorney. Lawyers must be satisfied that you have full mental capacity. Medical professionals can assess your mental capacity when it comes to making medical decisions. Some medical professionals are also qualified to complete capacity assessment reports, which are used in court proceedings. Finally, judges can make a decision about capacity based on a capacity assessment report. Or if a report is not available, then a judge can make a decision on the evidence that they have before them. You may hear people talk about capacity assessments, or maybe someone has suggested that you should get a capacity assessment. Capacity assessments are formal assessments of a person's capacity. They report on an adult's cognitive and functional capacity. Capacity assessments must be completed if you are applying for a co-decision-making order, a guardianship order, or a trusteeship order. Capacity assessments must be completed by a capacity assessor who is qualified by the Government of Alberta. The following professionals can be capacity assessors: medical doctors, psychologists, registered nurses, registered psychiatric nurses, mental deficiency nurses, occupational therapists, and social workers. However, not every person who works in one of these fields is automatically a capacity assessor. The person must be certified by the Government of Alberta. Capacity assessors must act according to a standard of conduct and must undergo training and continuing education. There are 3 phases in the assessment process. The first phase is the pre-assessment phase. In this phase, the capacity assessor must do a number of things, including meet with the adult and explain the process to them. The assessor must also get the adult's consent and determine the scope of the assessment. Does the assessor need to assess the adult's ability to make personal decisions or financial decisions, or both? The second phase is a medical exam. The medical practitioner must rule out any temporary, reversible medical conditions that might be affecting the adult's capacity. The third phase is a cognitive and functional inquiry. This is a standardized process conducted by the capacity assessor during a formal interview with the adult. During the interview, the capacity assessor forms an opinion about the adult's capacity to make decisions. The capacity assessor completes a capacity assessment report. The reports are different depending on the type of order being requested, whether it's a co-decision-making order, a guardianship order, or a trusteeship order. There are a few other things you should know about capacity assessments. You can have a person present to help you feel more comfortable and relaxed. That person must follow any directions of the capacity assessor. That person may be asked to leave if they interfere with the process, for example, if they answer questions for you. You have the right to have an interpreter or to use a device to communicate during the assessment. The assessment is done at a time of day when you can most likely demonstrate your full capacity. For example, if you are most clear in the afternoon, then the assessment can be done at that time. In general, a capacity assessment report cannot be dated more than 6 months before the date the court application is submitted to the review officer. If the report is older than 6 months, you can request in your application that the court consider the older report, but the review officer does not have to accept it. The court can order a capacity assessment be completed if your capacity to make decisions is an issue in a court proceeding. The court can also order that a capacity assessor be allowed to enter your home or that you go to a specific place for the assessment to be completed. If you refuse to complete the assessment or are somehow prevented from completing the assessment, the court can look at any evidence it thinks is relevant to your capacity. If the court thinks that it has enough evidence, it can make a decision about your capacity without a capacity assessment report. Capacity assessors can charge $500 for an assessment about personal or financial matters. If they are assessing both, the fee can be up to $700. The court can also allow a higher fee if the assessment is complex. The person requesting the capacity assessment can apply to have the government pay for the fee if they cannot afford it. However, the government will only pay for one assessment per adult per calendar year. There are many resources available that explain more about mental capacity and mental capacity assessments. The Centre for Public Legal Education Alberta has created a booklet about the Adult Guardianship and Trusteeship Act, and another booklet called Planning for Incapacity. We also have a tip sheet called Mental Capacity. These resources and many more are available for free online or in print. Visit our website for more information.
Thank you for watching this video from the Centre for Public Legal Education Alberta. We endeavor to make the law understandable for Albertans. You can find CPLE's resources on our website, cple.ca, or reach us via email at info@cple.ca, or simply by phone at 780-451-8764. Until next time.